who have the problem. Now the property developer, I mean, they're asking source of fund.
Yeah, I mean, yeah, everyone's just trying to cover themselves, I suppose.
Yeah. I mean, there's another issue of the data protection or the privacy. The things like client have all private investment, the information in the portfolio, and then the state agent asks for it. They are not like solicitors. They are not i.e. professional with a high code. And if the information get leaked out, cause something, but who's going to be responsible? It's like, why would the state agent have to have source of fund before they can sell a property? Wouldn't that be just for our professional buyer and seller solicitor to be responsible? Why do we have to provide information to them?
I guess, because
how do you protect the client thing and everything's out? See, it's like everybody. I just think the solicitor doing it should be sufficient. Bankers, of course, accountants, but why state agent have the same responsibility? Ask us for all the documents, and clients are not happy to give. And I can understand. They don't have, they are not regulated. So lots of questions. Right, we're just getting to we just now needed how many? I don't know.
We just hit 40 participants.
That's good. I think I'm expecting it will be about 100. We can give a couple minutes, then we can start.
All right.
Yeah. So they're all allowed in. But because I normally use other computer, I don't really use this as a laptop. I just don't know how to. Oh, yes, here. No, how many? Oh, no, I can't see. How many people here? I can't see it. That's all right. Let's give a couple minutes, then we can start. So we can have a bit more time for the question and answer Q&A.
Yeah.
Do you give more talks rather than just to us? Do you, you prepare all this information? Do you give talk to the other lawyers, different nationalities lawyers?
Yeah, I mean, I've done one or two. I think Kathy might have as well. Just on a variety of topics. It can be pertinent sort of AML topics. But yeah, certainly, different sorts of communities, different societies of lawyers. We do get around a bit and spread the AML message.
Do you do it online or offline? I mean, in the real meetings, do they ask you, or you actually, because Zoom's really easy that you just can be in your home, and then we can get unlimited people, who knows who have time can always join. It's much easier than you have to register and then people couldn't make it.
Yeah, it's been a mixture really. I mean, certainly, obviously over the pandemic, everything's been virtual. But we do, appear at conferences and evening meetings and things as well. But certainly, yeah, I agree that all these virtual meetings are very, very convenient to get everybody together at once, from the comfort of their own homes or offices.
Yeah, good, Lily. I think we're hitting 4 minutes past. Let's just start.
Yeah, we have about 50 participants, so let's start now then.
We'll go about 50. That's good. Let them come. They're probably more interested in question and answer section coming later.
All right, then. So should we start?
Yeah.
All right. Hello, everyone. Thank you to the audience for joining today. And also thank you to the SRA for kindly providing this webinar and giving our society members a chance to explore and understand this newly late Economic Crime Transparency and Enforcement Act 2022. And just to let the audience know, we will have a Q&A session towards the end of the webinar. So if any of the audience have questions, please just type them into the chat box and we will answer them at the end. Now, before I pass the mic over to Dr. Zhu, for those of you who are new to our society, Dr. Zhu is the president of the UK Society of Chinese Lawyers. And a little bit more about her background. Dr. Zhu is the president of the UK Society of Chinese Lawyers, and she obtained her doctorate in biochemistry and did her postdoctoral research with MIT and MRC in the UK before qualifying as a solicitor with Clifford Chance London. Dr. Zhu is devoted to the Chinese education and was head of the Chinese London Mandarin School for 11 years. In 2019, Dr. Zhu was awarded members of the Order of the British Empire and the Queen's New Year's Honours List for services to the law and to the Chinese community. You now have the mic, Dr. Zhu.
Thank you, Lily. Dear friends and members, solicitors and non-lawyers, welcome to our webinar. This is the third time that we work with SRA to provide a webinar. For those who do not know what is SRA, SRA stands for the Solicitors Regulation Authority. It aims to protect and help the public by make sure we lawyers uphold the law and keep the high standards. So the first webinar we had with them is on SQE, called the Solicitors Qualification Examination, which is a new route to qualify as a solicitor in England and Wales. Is introduced by the SRA in September last year. Ahead of the launch of the program, in January, we ran a webinar with an expert from SRA, give all the know-hows on how to do it to encourage more people to take on the route. The second webinar is on AML, which is part of the thing we're going to talk about today. We all know it stands for the anti-money laundering, and lots of us have to do the compliance during our work. We will also, I said we're going to run a webinar, and the SRA said the Ghana, British Ghana Lawyers Union would like to join us. We said, well, welcome. They have 900 members here in Ghana. So we had 3 speakers. The first one gave the guidance, explain what law says on AML. The second one is on the assessment, how the law firms perform. And the third one is on the actions against non-compliers. So it's a very interesting question and answer. And now, who are we? The UK Society of Chinese Lawyers was established 20 years ago. On 10th anniversary, we changed name to the current name. We aim to provide a platform to support our members, to help the Chinese business and communities, and to promote the legal literacy and cultural exchange. In 2015, I invited Donna Evans from International Relational Advisor from the Law Society to be our keynote speaker in our Chinese New Year concert celebration. And ever since, we always have the keynote speaker from the Law Society. In recent year, we always had the president, honored to have president of the Law Society to speaking to us to celebrate. We always have Chinese cultural events and the performances. In terms of the helping the community, we started the pro bono services in February 2017 with Chinese Community Center to provide weekly pro bono or free legal consultation to the public, initially in the center, to help them to stop the matter escalating, stop at the early stage. And thanks to our members, also Carrie Xu, who's looking after Rota, and the Chinese Community Center, the services survived COVID and last to today and still going strong. And in terms of the legal literacy, called 法律普及, we have given many talks on different subjects, from illegal immigrant to the employers' responsibility, and from civil to criminal law. but why this act? And this act actually is in urgent response to the Russian invasion of Ukraine, and is want to tackle the worry that dirty money has been used to purchase UK property and want to improve the transparency of the ownership. But in doing so, there will be a register, and the act giving authority much more power. So any offenders now will face fine and custodian sentences, which is a prison sentence. So this is the reason I think it's very important for more of us, or anybody, to understand as an individual or corporate, what is your liability, what you need to know to avoid being fined and being in trouble. So that's why we, well, last month I contacted Sean of SRA to ask to do a webinar, and she responded quickly and positively. And then now today we have Andrew and Katie. So thank you all three from SRA, and thank you Lily for the MC. And last but not least, thanks Cindy and Mr. Chu from K Education for providing the Zoom technical support for us today. Thank you.
Okay, thank you, Dr. Zhu, for your introduction. So now let's get to the main event of today's webinar. And up first, we have Andrew. Andrew is the AML Policy Associate for the SRA, conducting his work as part of their AML Directorate. His work involves writing guidances for the profession and feeding into governmental proposals on AML supervision of the legal sector. Andrew led on the SRA's recent inspection by the Office for Professional Body Anti-Money Laundering Supervision. Andrew has also worked in the SRA's proactive supervision team, involving the on-site inspection of AML controls within legal practices. Andrew has previously worked as a compliance manager and AML supervisor of teams for national and regional practices in the UK. He has also previously worked in the investment banking and consumer credit industries, where he specialized in anti-financial crime subject matter and also identity verification. I now pass the mic to Andrew.
Thank you very much, Lily. Hello all. Thank you for inviting us to speak to you today and for the kind introduction. As our host mentioned, I'm Andrew Bryan. Today I'm co-presenting with Kathy Carley-Ahona. We both work within the Anti-Money Laundering Directorate at the Solicitors Regulation Authority. So our presentation today concerns the newly enacted Economic Crime Act 2022 and the implications for owners of UK property. And we'll also touch on elements of anti-money laundering compliance relevant to the Chinese community. But please note the Economic Crime Act part of our presentation is our interpretation of the new legislation, which is drafted by Her Majesty's Treasury, and how this will affect solicitors that we supervise. We've issued preliminary guidance on this topic that you might have seen, and hope to provide further clarity when the second part of the Act is published later in the year as well. But now I'll get on with the main body of the presentation. Okay, so you'll be aware that the first part of the Economic Crime Act was laid in March of this year. The bill appeared very quickly and passed through Parliament quickly in the wake of the Ukrainian conflict, and it's evidently been drafted for some time. It's been, sat on a shelf. The Act itself covers three elements designed to improve the effectiveness of unexplained wealth orders, particularly limiting costs around them for law enforcement, and to streamline sanctions enforcement, making it easier for the Office for Financial Sanctions implementation to fine for sanctions breaches and to publicly censure companies. But this webinar, however, will focus on what the majority of the wording of the Act concerns, and that is the registration of overseas corporate entities that own UK property. So I'll start with an overview. So this register of overseas entities is going to be operated by Companies House, otherwise known as the registrar, and I'll refer to them as that. And they will also conduct enforcement for non-compliance with the new legislation. So any overseas registered companies that own UK property will be required to register the details of the company and their beneficial owners with the registrar. But the database isn't live yet. But when it does go live, entities will have 6 months to enter their details before they attract the new enforcement process. As it says on screen, the new rules apply to properties bought since 1999 in England and Wales and from 2014 in Scotland. The legislation also mentions that any changes in ownership from February 28th, that's actually before the legislation was published, any changes from February 28th will also need to be recorded into the database. Otherwise, this will result in fines or imprisonment. So this measure is designed to capture any beneficial owners who had heard news of the legislation and were trying to shift their holdings to other parties to preserve their anonymity or avoid scrutiny, etc. Because of this measure, the original beneficial owners before any changes will also have to be recorded into the database. So for new purchases of property, entities must register with the registry before applying for land ownership. One can't happen without the other. Overseas entities will not be able to buy, sell, transfer or lease land or create a charge against the land in the UK unless they've registered with Companies House. Also, this information is required to be formally reviewed on an annual basis for all overseas entities that hold UK property. And they have to go for a sort of annual re-registration process. Non-compliance with any of the new rules can, as I say, result in fines or imprisonment. Fines are suggested to be up to £2,500 a day for each officer of the company, which generally means secretaries and directors, with also jail terms of 6 months or more that could be imposed for serious infractions. As I mentioned, the gathering of data, its maintenance and all of the enforcement action will be handled by Companies House. And this is the biggest change to Companies House's operation since the 1800s. And I understand that work continues at great pace to prepare Companies House technologically and operationally for its new responsibilities. So to get into the data requirements of the register, the actual stuff that needs to be reported into it. When submitting an application to the register, the legislation requires that the following information is provided. First, a statement that beneficial owners have been identified, that there are no other registrable beneficial owners as well. And the general rule of thumb is to report those with an interest of over 25% or those that are managing officers of the entity that have significant control one way or another. And secondly, a formal confirmation must be provided that the required information has been obtained for those beneficial owners. And these are sort of basic personal details that I'll show in a little more depth a little later. So the application will also require enclosure of verification information. As I mentioned earlier, the second part of the Act is yet to be published, and the first part alludes to mandatory identity verification requirements for registrable beneficial owners and managing officers. These requirements are going to be created by the second piece of legislation, and it's unclear at this stage what these verification requirements will be or how they will be expressed, but it's likely that they will be aligned with the money laundering legislation, something like getting a verified passport and proof of address or a digital equivalent of the same. A crucial part of an application is also to provide the name and contact details for an individual who may be contacted about the application. So this contact is likely to be a legal firm in a lot of cases, for those firms that offer corporate admin on behalf of their clients. I anticipate they'll have a glut of work to do over the coming year, particularly those in commercial real estate that have incorporated SPVs overseas, for example, on behalf of clients to assist them in acquisition of UK property. So the required information. So there are two lots of required information, one for the entity and one for the beneficial owners or managing officers. So as I mentioned, this is separate to whatever documentation might eventually be required for identity verification. So listed on screen is all the information that will need to be provided for the entity itself. And these are shaped to record the official company registry information for the overseas entity. particularly its place of incorporation, its place of registration and operating addresses, the company type, and the details of the public register where its registration information is kept. It's also welcome to me that they require an email address for prompt correspondence, which is especially useful for when Companies House are trying to enforce their strict deadlines for compliance. So in addition to the entity, as I mentioned, basic information is also required for the beneficial owners or managing officers. And the required information includes their name, their date of birth and service address and residential address, but also when they become a registrable person, also how they hold significant influence or control, for example, as a shareholder or trustee, and whether they are subject to financial sanctions. I assume anyone registered information would perform sufficient enough screening to know whether the beneficial owner they are registering is sanctioned. But just to quickly mention, HNT's list does have a search function now to make it easier to search the list if you ever need to. So you might ask, what of this information will actually be available to the public? So it's intended that the information will be available in a public register that's free to search through, like the present company information on Companies House that we used to, but not absolutely everything will be available for public view. Particularly a registered beneficial owner's full date of birth will not be included in the register, nor will their personal residential address. That detail won't be there, but of course Companies House will retain these details internally. Also, the name and contact details of the person farming all the information to Companies House will not be available to view by the public, worth knowing for firms that are servicing their clients. I'll just take a drink 1 second. Okay, so some other points from the legislation that I want to pull out. A bit further on how shareholders and beneficial owners are classified according to the legislation. Any two persons that jointly hold a share are both separately treated as beneficial owners for the purposes of the register and will have to submit the same registration details. Also, where properties are owned by trusts, those with significant control over the trust and the settlor and grantor must register. Information must also be recorded by the beneficiaries if they are deemed to be registrable beneficial owners, i.e. they have a significant interest in the trust. In partnerships, limited partners are not required to register. General and managing partners are presumably required to do so, again, based on their significant control over the partnership. So on the enforcement side, the Land Registry will file a restriction against the property if it's owned by an overseas entity whose information has not been provided to the register. This will prevent any transfer, lease, sale, or purchase without proper registration. The official restriction will be imposed until the requisite information has been provided to the registrar. And there will be an information gateway between Companies House and the registry, obviously, to ensure that their data is aligned and they communicate with one another to enforce these restrictions. There are exceptions to these rules relating to bankruptcy or where properties are otherwise required to be transferred by court order or similar, and I think they will come about in the secondary slice of the legislation. As I mentioned earlier, entities must confirm their details on an annual basis, or the aforementioned land registry restrictions will be imposed. The penalties for non-compliance with this are severe, and like before, cost thousands of pounds a day per officer of the company, or jail sentences can be imposed, which will be for periods of months. And these are obviously intended to be a deterrent to those who don't wish to comply with the new rules. Separately, a formal application will have to be made to remove an entity from the register. Entities won't fall off the register by themselves, and a lack of attention could result in an unexpected land registry restriction, where the registrar is still expecting an annual update from the entity. There's no further information available on this yet, but the government are intending to build in a mechanism where natural person owners of property affected by an entity's non-compliance with the registry are able to use an alternative route to register ownership with the land registry. I guess this would be where the corporate administration is out of their hands and the party responsible has been able to fulfill the new requirements for some reason. I expect more information will be provided on this in the second act, which brings me nicely onto my next slide. So the second part of this key legislation is expected in the summer, which will explain the ID verification expectations, what they will be for each beneficial owner that I mentioned earlier. That most crucially, the second piece of legislation will confirm when the registry will actually go live, which will officially start the 6-month time limit for all foreign companies to have their information registered. Also, overseas entities should expect a letter from Companies House. Companies House will soon be writing to all overseas entities who own land in England, Wales, Scotland, and Northern Ireland to make sure they know about their new responsibilities. I would expect these to arrive within the next couple of months. Okay, so shifting focus now slightly onto AML compliance away from the Registry of Overseas Entities. We thought it'd be a good place to highlight that we recently participated in a webinar on Chinese underground banking with the National Crime Agency and the Law Society of Scotland. This has proven to be a pertinent issue where Chinese legal consumers are using illicit means of moving money out of the country due to currency restrictions. Particularly, we see this as used as students wishing to acquire property near universities in major cities. We found that smaller firms and solicitors were targeted, and this might be for their anticipated lack of compliance sophistication. Now, obviously, we would expect all solicitors we supervise to obtain comfort in their client's source of funding and to record the rationale for that comfort in their matter risk assessment, recorded on a case-by-case basis. If a client cannot produce evidence to support the origin of the funding, then firms shouldn't really proceed. At time of writing, guidance pieces are being written paying attention to this topic and the implications for solicitors. There's going to be a piece on this from the SRA, and one also from the Legal Sector Affinity Group, which is the group comprising all the other legal regulators and ourselves. And these will share some red flags and customer due diligence techniques to assist in mitigating the risk of involvement in this criminal typology. Okay, so now we'll move on to AML supervision activities, and I'll hand back to Lily to introduce Kathy. Lily, over to you.
Thank you, Andrew, for your talk. And just to remind the audience member again, you can just type any questions you have into your chat box, and we will answer that towards the end of the webinar. So up next is Kathy, who is a team member, a team leader, in the AML proactive team at the SRA, overseeing the AML reviews of firms to ensure their compliance with the regulations. Kathy has over 10 years experience of working in the legal sector and on regulatory and criminal investigations. So after qualifying as a barrister in England, Wales, and in the Republic of Ireland, she joined the Serious Fraud Office, where she worked on several high-profile cases of fraud and money laundering investigations before joining the SRA in 2017. Kathy, you now have the mic.
Thank you very much, and good evening, everyone, and thanks for having us here today, as Andrew said. So as Lily and Andrew mentioned, I'm a team leader in our AML supervision team at the SRA, and I manage a team that conducts visits, carries out desk-based reviews, and other ad hoc work such as thematic projects. And over the next 10 minutes or so, I'm going to talk briefly about two things. So firstly, our annual AML report, which was published in October of last year. And secondly, I'm going to give an overview of what we have found on our visits and desk-based reviews over the last year or so, with a sort of specific focus on firms acting for members of the Chinese community or where funds have come from China. So beginning then with our annual report, which provides a detailed overview of our work during 2020 and 2021. During that period, we visited a total of 85 firms and conducted 168 desk-based reviews, with the majority of these being rated as partially compliant. And one of the emerging risks that we discussed in that report is that of evading currency controls, which Andrew briefly touched upon earlier, and the risk of fraud that comes with that. And there is now, of course, an increased awareness of the risks posed by currency offshoring, where the government has essentially placed restrictions on money moving in and out of the country. And an example most frequently cited is, of course, the Daigo system of shadow banking, which is used to move wealth out of China, often through chains that include cash produced by criminal activity. And we as a team have spotted a mix of issues within this, including concerns with the source of funds, which I'll go into in some more detail in a moment. Moving on then to our visits and our desk-based reviews. As a team, we have now returned to in-person visits this year following a period of conducting visits remotely as a result, of course, of the coronavirus pandemic. And we have again increased the number of visits and desk-based reviews conducted compared to last year. And in terms of what we're seeing as a team through our proactive supervision, I would just like to take you through that. So on firm-wide risk assessments, we are still seeing the use of a lot of templates, which is of course not a problem in itself, but these are often not tailored to the firm itself. So some still fail to address one or more of the 5 risk factors, or have a tendency to focus on what firms don't deal with, as opposed to focusing on the risks they are in fact exposed to. And it's really, really important to sort of get your firm-wide risk assessment right, because it's sort of the backbone of your AML compliance framework. And it's really important that you explore each of the risk areas in enough detail to really sort of tease out what risks your firm is exposed to. And for example, with geographic risk, a lot of firms still don't set out in which countries their clients are based or where they provide services to. But having said that, we have seen an overall improvement in firm-wide risk assessments and policies, controls and procedures that we're seeing in terms not only of compliance, but also of quality. So that's great. On policies, controls and procedures, topics which are frequently missed out include things like reliance under Regulation 39. So if your firm doesn't allow this, you should clearly set this out in your policies, controls and procedures so that fee earners are aware. And if you do allow it, you will need to carefully set out what is required of fee earners in that regard. Similarly, simplified due diligence under Regulation 37, as with the reliance point that I just mentioned, even if simplified due diligence isn't used by your practice, you should still set that out in your PCPs. So if you do apply simplified due diligence, you should set out the instances when it may be applied as well. So that's clear to fee earners who are applying the policy. High risk third countries, again, often not addressed in policies, controls, and procedures. And where it has been mentioned by firms, it often incorrectly refers to the old EU list. And as most of you will know, the UK now has its own list of high-risk third countries, which is of course set out in Schedule 3ZA of the regulations. And it's worth noting that this list frequently changes, so it's something you should keep an eye on and make fee earners aware of. And of course, the reason why it's so important to identify where a person is established in high-risk third countries, because the regulations require firms to apply enhanced due diligence in those circumstances under Regulation 33. And you should also be aware that sort of geographic risk generally isn't just limited to jurisdictions listed as high-risk third countries in Schedule 3A of the regulations. So you should also have regard to other credible and independent sources when considering geographic risk generally. In terms of other things that we're seeing, audits are becoming more widespread, which is really good to see. And do consider, if you need to do one as a firm, taking into account the sort of size and nature requirement that's set out in the regulations, and make sure that you're meeting the requirements under Regulation 21 as well. We're seeing that some firms are still relying on personal knowledge or knowing the client for a long period of time as a reason for not conducting customer due diligence. And there is, of course, no provision in the regulations for waiving CDD requirements on that basis, and taking that approach won't satisfy the requirement to undertake independent verification of the client. Client and matter risk assessments, unfortunately, we're still seeing problems with these. And just to flag quickly to you, the key things to remember with client matter risk assessments is that they need to be documented. So you need to be keeping an audit trail around your decision making on those. You need to document the circumstances and the identified risks, which with reference to your firm-wide risk assessment. You need to rate the risk that you've identified. And finally, you should justify the risk rating that you've applied with the supporting rationale. And essentially, I think the key thing with firm-wide risk assessments is that it shouldn't just be a tick box exercise, and you should be including as much detail in the risk assessments as possible, so that's clear. On to source of funds then. We are finding that firms are not really recording enough information of how source of funds have accrued. So we have seen cases involving monies coming from China, for example, for the purchase of property where source of funds was an issue. And as Andrew mentioned, we have seen a lot of cases where firms act for students purchasing property off plan, or where we have a large amount of family members or even friends contributing to purchase of properties. And firms generally tended to obtain some information about the source of funds, but they just weren't going far enough in our view. And a lot of those firms do conduct enhanced due diligence in those circumstances, and we agree with that approach as we consider that those types of cases are high risk. So just a few things then to consider when you're acting for someone with funds coming from China. Firstly, you need to think about whether the client may have misdeclared the purpose of the transfer on the official form. So in which case you need to consider whether you want to continue acting for someone who may have made false declarations to the authorities. You know, you need to think about what that means in practice. How do you deal with that going forward? Do we want to make a suspicious activity report to the National Crime Agency, for example? And you also need to consider, you know, has the client perhaps used underground banking where the proceeds more often than not stem from criminal proceeds? And I think the key is to really ask further questions about the source of funds. Things like if there's a broker involved, you know, are they really who they say they are, or are they really an underground banker? Are the funds family loans? Are they from friends? If so, you know, why have they lent all this money to your client? Does it make sense? Things like, is there a loan agreement in place? You know, what's really going on? You need to find out what's really going on there. Are all those individuals in fact part of the underground banking network? And of course, you also need to be aware of your obligations under the lender's handbook and acting in accordance with that, where loans or gifts from family members are involved. And I think what's important to remember generally with source of funds and source of wealth checks is that they shouldn't be limited just to your processes involving politically exposed persons or high-risk third countries. Regulation 33, it does state quite clearly that enhanced due diligence should be considered in any case identified as one where there is a high risk of money laundering or terrorist financing. And of course, one of the checks you may choose to carry out as part of enhanced due diligence may include going further to understand sort of the background, ownership and financial situation of your client, and indeed any other party involved in the transaction. And it's sort of important to remember as well that understanding the source of funds and source of wealth is really crucial to understanding the risk of the transaction itself. And it should really be approached as an opportunity to protect your practice from being used for money laundering. And I just wanted to finish off then by going through a few red flags to underground banking that you should look out for. And some of these include things like lump sums being received from companies with no connection to the customer, sums received in unusually rounded figures or from questionable sources, cases where, you know, you've got information accompanying a transfer which appears false or contradictory. And sometimes sometimes customers insisting on translating their own documents can also be a red flag. Next slide, please, Andrew. Thank you. And in terms of help and guidance, obviously help is available on our website as always, as well as from our ethics helpline. And if you have any questions at all or you're unsure about anything, do give our colleagues in ethics a call and they're always happy to help. And you can also access our previous webinars from our YouTube channel if you're interested in those. And details of how to report breaches are shown on your screen now, and our red alert line can be used for making critical confidential reports. Thank you for listening, and Andrew and I are happy to take any questions any of you might have.
Thanks, Cassie, for your talk. I see our chat box already have some questions, and the first one is relating to the company's house. So it says, do we know how long company's house will take to issue confirmation certificates after the application is made?
At the moment, no, we don't. I can't give any further information on that, but I would hope it would be prompt, given the criticality of, these are time-based fines and imprisonment of these daily fines of £2,500. Hopefully, it will be relatively instantaneous. But I don't have express confirmation of how long that would be at this time. But hopefully, it will be clarified later in the year. Probably around August, September time when the next part of the legislation comes out.
Thank you, Andrew. The next one is on the exemption at land registry and court order. Please give examples of when the court will exercise its power to make such an order, and how does this power work in relation to litigation in the family courts?
I can't really provide for the kind of a legal take on that. It was just my interpretation of what the legislation actually says. So short of getting sort of independent legal advice on that, I can't give examples. But it is what's been written into the legislation so far. And so I included it for your guys' consumption today.
Thanks. So another question is, how often will this register be updated?
I would expect that it'll be updated, on a daily basis, as is Companies House, which is updated literally all the time, every day. So I would have thought, all day whilst they're in office, they'll be ploughing information into the new register of overseas entities.
Thank you for that. There's some other questions on when will the SRA provide guidance on funds coming from China?
Well, that guidance is being worked on at the moment by myself and some colleagues, and I would expect that to surface within the next couple of months. It's in a pretty advanced stage now, so it will be available pretty soon. So do keep your eyes on the compliance part of SRA update. As I expect, as I say, it will turn up quite shortly.
Thanks. I also just have a question on, I understand previously you were talking about trusts, they will be included in this register as well. Does that apply to only UK trusts or both UK and non-UK trusts, as long as UK property is involved?
I think it's all trusts, all international as well. They will want to know who controls them, who is at the helm, whether that be significant controlling beneficiaries, settler, grantor, trustees. They'll want all of that information and all of that to be kind of offered up to the registry. In terms of supporting documentation behind trusts, obviously that's yet to be defined. The actual kind of supporting kind of documentary evidence that they might need for that. But yes, it will apply internationally.
I see. Thank you for that. And so what about who will be responsible to do the registration?
So the legislation refers to the entity itself. So that's a little bit unhelpful, but makes it seem like they'll approach the entity at its kind of registered address first and foremost, and then at that point somebody will offer their details and say, I am the person to be contacted about the registration of the entity. So all indication is that the entity will be contacted at its registered address. But then I assume from then onwards, as soon as the contact details have been provided of the person that can be contacted to provide the beneficial ownership information, it will be them that will be contacted from there on.
Thank you. Is there any more questions? Oh, we just have one more question. Hi, does the Chinese fund invest in UK company needs to do CDD now?
Do Chinese funds invested in UK companies need to do? Does that mean Chinese businesses that invest in UK companies?
Yeah, I'm guessing this is what the question is meaning, or if it says individual investments.
Is that from the perspective of the individual or the UK company? I'm unsure of the context of the question. Okay, investing in Chinese UK company. To do CDD now. I mean, it would probably be worth it. If you're going to contribute funding to a company to check its financial good standing and who's actually in control of it before you effectively become part of it, particularly if you want to become a shareholder or one of its directors. You want to have more information on the purpose of the business, who they associate with, how they're controlled, and where the profits come from, and their general financial good standing. But from that angle, it might not be a requirement. But just for one's own peace of mind before they offer up any money to an entity.
All right, thank you, Andrew. So the next question is on what is the solicitor's responsibility in terms of the register?
Well, in terms of solicitor's responsibility, I mean, if a solicitor is the kind of go-to sort of admin person for an entity that they've incorporated on behalf of a client, then they will be that contact person that needs to give that information to the registry. So, in terms of the letter of the legislation, it doesn't specifically refer to law firms, but I do know that law firms offer a great deal of corporate services to entities on behalf of their clients. So it would probably be their client's expectation to pass information to the registry. So basically, if they have that agreement with their client, then it's down to them to report that information into the new registry.
Thank you, Andrew. The next question is about the transfer methods. Does the transfer method need to be clarified as well?
Is that going back to the investment in a British company?
Yes, it's from the same audience member.
Okay. I suppose that would be down to the company to check the the transfer method and see if that was something that they usually use and consider to be an above board transaction. I would have thought they'd have standard methods of welcoming investments into their bank accounts. So I'd expect they would do some diligence on their investment before they before they welcome that investment.
All right. It seems that there are no more questions from the audience. Dr. Zhu, should we give the audience a few more minutes, or should we end now?
And what about Katie? Would you mind to maybe elaborate a bit more on the firm's duty, how to get the source of funds in dealing with Chinese clients that you mentioned before? That it seemed to be a quite hot topic and difficult task. That what kind of evidence, what kind of document that we as a solicitor, if we act for the clients, invest into the UK, must get to actually release our AML responsibility?
Sure. So, I mean, this generally the type of documentation that you should be willing to accept to verify sort of source of funds should really depend in the first instance on sort of the level of risk presented by the customer. So that should be your starting point, I think. So the higher the risk in your view, based on your client matter risk assessment, the more comprehensive really and the more reliable the documents you obtain should be. So, I mean, it really is a case of scrutinizing transactions on a matter by matter basis with the ultimate objective of really understanding what the source of funds are for the transaction. As always, you need to take a risk-based approach, and if you are not completely satisfied what the source of funds are, you need to consider whether you want to be acting for that client. And in terms of specific documents, I think again that very much depends on the situation. So that's quite hard to answer. I don't know if there's anything else that you want to add on that one, Andrew.
I suppose the crux of it for international clients is ensuring that documentation is translated and translated independently by somebody you're able to verify, be that a professional translator or a solicitor overseas or something of that nature. But generally, the approach is sort of similar, whereby you're getting hold of bank statements, you might be getting hold of wage slips or company accounts to evidence profits and existence of companies, or people's bank statements to evidence their savings amassing over time, and having those translated and putting them all together. But I always like to stress that you don't need an absolute audit trail of every last cent, because that might just not be proportionate and might irritate your client. It's about just getting comfort with the amount of documentation that you've put together. But as I say, for clients from overseas, you're going to want to get some independent translation of their due diligence documentation, obviously if you don't speak the language, so that you know what it says before you proceed with the transaction.
I came across some cases, just wondering if you two can shed some light on. My clients say the purchase funds were from parents. The parent could be a farmer, Chinese farmer, fisherman, or teachers for 20, 30 all their life. So they saved, say, 20, 30, or 50 years of their savings and now gave to their children or their own daughter or son to buy a house or property in the UK. And they just told me they don't have a bank statement, they don't have an employment letter. There's nothing really much in paper. Like fishermen say, we just get a fish aboard and send, and then we get a cash. The fish go to the restaurants in the village. We don't deal with money going to the bank. But yet there's for 30 years, we have sold fish. The parents have saved the money, all the teachers or the butcher with the same thing. I have been asked them to provide pictures of the fish coming to the shore, the fish go loading to the restaurants and cash change hands, or the butcher shops, all the teachers be difficult because you can't go to take the picture of the classroom again. But what other documents that you think that will suffice or help us as part of source of fund when the client's in that situation?
That is fairly extreme if there to be no kind of paper trail of of a business. But I mean, I think in circumstances like that, you can afford to be a bit of extreme and take photos of to prove stock and the sale of stock and the existence of the place where the stock is sold to. I mean, obviously my knowledge of jurisdictions around the world isn't that in depth as in terms of kind of what paperwork might be available, especially for businesses. But I wondered is there any kind of tax registration documentation that could be obtained to prove existence of the company? Is there any kind of company registration stuff to prove existence of the company?
They deal with the cash, and the parents save the cash, now giving to children to buy a home. So the question is, are we going to say, we can't act for you, or you have some way we can help those people to buy a property? It's like how much risk we have in taking on, try to help those people.
I mean, the crux of it really is ensuring that you are comfortable, and getting as much evidence as you can to support that. And if you can't, then unfortunately you won't be able to act for the client. But I mean, by all means, be as creative as possible, to obtain evidence, whether it be photos or written statements from people or something like that, to support the existence of these businesses that have existed for many years and have accrued lots of money, which they then passed on to their families. But there's no kind of rule book for circumstances like this, and I think you have some creative license to see what you can possibly put together. But I think taking photos is a decent measure, a decent pictorial evidence to prove the existence of a business. But but yeah, interesting. Perhaps you could ask if they've had any dealings with any professionals ever. Any
they don't really
solicitors
use lawyers or solicitors in the village.
Local government officials, anything like that.
They have a 村长, they have a head of the village, can write a letter. I did ask for that. So as you say, the statement, yes, we can get some statement from the head of the village. It's like a school, headmaster, they, looking after the village. But also in the question to Katie, if the firm being investigated, say the case, you come across a case like that, they should have a source of fund, but they couldn't really provide any evidence, but there was a statement to saying where the money come from. What would be the attitude of SRA?
Well, again, I think it depends on the situation. Again, I mean, what do we have? What type of client is it? I think it would depend. We would look at the client matter risk assessment. What were the risks that you'd identified on this client, and ultimately, whether it was proportionate in the circumstances. I think we sort of need to look at, whether that was adequate in the situation.
I think the difficulty is we have a duty to serve the public, but yet we need to protect ourselves. So it would be easier. We just say, no, we can't act for you. But I mean, they say, please, we want to buy this house. And it's like where our duty, what is our responsibility, duty lays. And, what is it? We really need some clearer guidance from SRA on whether we should act at all.
Yeah, I mean, yeah, it is difficult, and it's to do with, identification, verification of the client and of the source of funds. But yeah, I mean, certainly, we've got a webinar coming up on source of funds actually, which where more of these questions could be posed and addressed, and I'll speak to the authors of that as well, to ensure they consider these sorts of situations. Because it is difficult and does put you in a difficult position. But yeah, I hope you can come up with creative ways of putting evidence together to prove the existence of businesses and sources of wealth over time for the sake of your clients.
What about school teachers? What other evidence could you get? You can't even take pictures. They've been school teachers for 30 years. And they saved funds. Now, shall I take on the case? Or shall I say, no, you can't provide source of fund, I'm in risk. I can't take that risk.
If there is no, say, register of teachers in that particular jurisdiction, perhaps you could ask another teacher, another professional in the same school to kind of give a written statement to confirm their employment there. Or you could, have a look on the web and see if there's any evidence of the school's existence. Maybe if they've been mentioned in news articles, or if the teachers themselves have been mentioned on the web. But I think perhaps in a lot of situations like that, it might be worth just getting another professional they work with or somebody they know in the village to talk about their existence and what they know of their financial dealings.
With the students.
And that would be, but perhaps not their students, but and that would be one piece of evidence that you could put into your sort of customer due diligence bundle. But as I say, just do what you can to obtain as much as possible to get you comfortable. But it is tricky. I accept that.
Yeah, I mean, we're not talking about 5 million, 10 million. We're just talking about small people who are hardworking for many, many years. And I feel bad not to be able to help them. Any more questions, Lily, there?
No more questions from the audience here. Yes, I think those are all the questions we have now. Any more questions from audience or from Dr. Zhu yourself?
I'm fine. Thank you both for giving an excellent talk and answer all the questions.
All right, then we will end the webinar here. Hopefully the webinar has been informative to everyone here today. It's been a pleasure having SRA here, giving us some guidance surrounding the launch of this new Economic and Crime Act. And as you saw, many of our members deal particularly with overseas clients in the property business. So this webinar has really come at the perfect time. We are actually right on time. So seeing as the time is about 7 p.m., let's end the webinar here. Thank you again to everyone attending, and also to the SRA. Thank you to Katie and also to Andrew.
Thank you very much. You're very welcome. Thank you for having us.
Thank you very much, everyone.
Okay, bye-bye then.
Bye-bye.
Bye-bye.
Thank you. Thank you.